This is the second part of the video 47th. Because of some unintentional error, it has got interrupted. So let's start. In Sarat Chandra Day versus Gopal Chandra Laha, it was held that even if it is made unintentionally, even if there was no intention to deceive, yet if representation has been made, it has been believed upon and acted upon, then the uh, this would apply, or estoppel would apply. Second is that it may be because of any act or omission, both are covered. That is, if but it should be a legal obligation to act, or legal obligation to omit, or legal omission must have been done. So, in suppose a person has got, there is some transaction, a person has got duty to speak and he didn't speak, then at that time, because it was his legal duty to speak, so the estoppel would apply against him. Now, so these are the three conditions, that is belief, act, and representation. Now, what are the various types of estoppel? So basically, there are three types of estoppel, so that you can remember it. I have made CDR, call detail record. One is estoppel by conduct. This is what we have studied now, the estoppel by conduct. That is, there is a belief, there is an act, and these are based on a representation made. Estoppel by deed. So, in case deed means that it is a solemn, suppose a solemn engagement by deed under his hand. So, if a paper or documentation has been done, and based on those documentation between two persons, there is certainly a deed, estoppel by deed is also created. And third is estoppel by R is estoppel by record. So this can be that if there is already a record which mentions certain thing, then the other person cannot be allowed to deny it. For example, res judicata. That is, if a court has given certain judgment, then certainly it is, and a person has stated certain statement in that particular uh, proceeding, then he is stopped from denying it in later proceedings. So these are the three types of estoppel: estoppel by conduct, estoppel by deed, and estoppel by record. This is important, that what we are studying under the evidence is estoppel by conduct. Now, what are the various exceptions to it? This is important. What are the various exceptions to it? So, in order to know the exceptions, what we should remember is that the, as you can see, it is a slum and it is a bank. So, slum bank is what you should remember in order to learn that what are the various uh, exceptions to the law of estoppel. So, first is that S stands for sovereign acts. So there is no estoppel against a sovereign act. So against a legislature or a legislative act or an executive act, or a judicial act, there cannot be any estoppel. Please remember, there is something called promissory estoppel, which has newly come into being, that we'll study in the next chapter, where certainly governments are also bound by their promises. Second is law, L, that is L is law. So there is no estoppel against law. That is, suppose if A says that this is the law on a particular subject, and believing A, suppose B acts, and later on A says that no, law was not this, then in that case B cannot claim that as A has earlier said this is the law and I have acted to my detriment, so A is stopped from claiming the law is another thing. No, because law is fixed, law is written, so it is for B's duty to verify that whether that particular law is there or not. So there cannot be any estoppel against law. Third is U, that is, it should be the ultimate cause of loss. That is, the proximate cause of loss to the aggrieved party should be the representation made. It should not be some other fact, and it cannot be just an adducing fact to it. So this should be the main fact. Then U, then M, minor. So there cannot be any estoppel against minor. So if a minor says that I am of age, I am more than, say, I am of 20 years of age, and he enters in a contract. Later on he says that no, I wrongly said that I am 20 years of age. Actually, I am just 17 years of age. So in that case, one cannot claim law of estoppel against minor and uh, get the contract valid. The contract would still be void. However, equity demands that the benefit which the minor has retained, he should be it should be returned. Next is B. Now we will be coming on bank, that is B. Both. When both the parties claim when both the parties claim estoppel, so then they will, suppose A is also claiming estoppel against B and B is also claiming estoppel against A, then they will cancel each other out and law of estoppel will not apply. Then sixth is A, that is act or statute. So there cannot be any estoppel against statute. So you cannot give a that an assertion against the, or claim a benefit against the act or the statute. Next is 7, that is N, negligence. There cannot be a estoppel against because which has come because of the negligence of the other party. Suppose A claims something and B could have had easily found out the truth behind it. So in that case, B has been negligent in finding out the real truth. So the law of estoppel would not apply. And last is K, that is knowledge. So in case the B had already the knowledge that A is a minor, and yet based on representation he enters into contract, then certainly B's conduct was not up to mark or was not fair. Therefore, law of estoppel would not apply and we will not get any benefit under it. So that's all for today. We'll just revise what all we have done, and remember it is now in two parts. So video number 47, chapter 8, Estoppel, section 115 to 117, and where we did that nature is that it is a substantive in nature. Principle behind it is to prevent fraud, and a person cannot blow hot, hot and cold at the same time. A man cannot probate and reprobate at the same time. Elegans contraria non est edundis. Person alleging contrary fact will not be heard. Then we saw that it applies only to civil cases. In criminal case, it does not apply. There is a term called issue estoppel in criminal case, that if a particular fact has been established by in the court during a proceeding, then evidence cannot be given to turn down this fact. Then definition of estoppel, we saw that person uh, asserts, if person asserts some fact, later on he cannot be allowed to deny it as he becomes bound by it. Then the essentials, we saw that there are three essentials involved. One is that there should be a belief on the representation or reliance on the representation. Then the aggrieved party should have act detrimental to his interest based on representation, and then there must have been a representation as such. Representation can be intentional or unintentional. In both cases, it will apply. It can be of an act or an omission, but remember it should be a legal obligation. Then types of estoppel, we saw three types of estoppel. Estoppel by conduct is what we are referring in law of evidence. Estoppel can be by deed, that is by documentation between the two parties, or it can be by record, that is some official record or other private record like res judicata. Then the exceptions to it, we saw that there are 8 exceptions to it. One is there is no estoppel against sovereign act. However, promissory estoppel concept has come. Then there can be no estoppel against law. There, the loss, the representation must be the ultimate cause of the loss. Then there cannot be any estoppel against minor. Then, if both parties claim it, then they will cancel each other out. Then A, that is there cannot be estoppel against act or statute. Then there cannot be estoppel in case with ordinary prudence the other party could have discovered the truth. So if the cause has arisen because of negligence, then certainly there will be no estoppel, and there cannot be any estoppel in case the party knew the actual truth or the reality. So that's all. In our next session, we will be doing section 116, 117, promissory estoppel, estoppel against universities, and compare the term estoppel with terms like admission, waiver, res judicata. Thank you, friends.